So yes, today we are discussing the maxim equity follows the law. That essentially means, as we discussed in the last class, that equity does not conflict with the law but is complementary to the law. So to what extent that assertion is true, we already had a detailed discussion about that when we deliberated on different perspectives given by different thinkers like Maitland, Hoffel, etc. etc. So however, this maxim conveys the idea that equity is not in conflict with law but is supplementary to the law or complementary to the law. So it only does what is still left after the application of the law. So as Maitland had famously said that every jot and every title of law was to be obeyed, but when all this had been done, something might yet be needful, something that equity would require. So what equity does is, when everything else has been done, but if there is something still required to be done, that is what equity does. So it does not, according to Maitland, go against the law. Similarly, Judge Story had said that where a rule either of common law or the statute law is direct and governs the case with all its circumstances on a particular point, the equity court is as much bound by it as a court of law and can as little justify a departure from it. So what he is essentially saying that if the law is crystal clear, if it is dealing with a subject matter in toto, there is no left for application of the rule of equity as it exists now, then of course there is no application of equity. So that essentially means that equity follows the law according to them. But we have also seen when we discussed about Hopeful's take on whether law and equity are complementary or contradictory, we see that in those examples that were given by him, you can say that yes, equity does not really follow the law. It even goes against the law. Or if there is a conflict, then of course equity prevails, as is accepted by Hoffel, as is asserted by Hoffel. So yes, anyway, there are two different meanings in which, not two different meanings, essentially, and there are two different ways in which this particular maxim is used, okay? That the first sense is equity adopts and follows the rules of law, okay? So what it essentially says that everything that happens to law, okay, in the same way it also happens in case of equity. So for example, if there are different kinds of properties, okay, fee tail, fee simple, fee absolute, whatever different kinds of properties are there, the same applies to the case of equity. So yes, equity, adopts and follows the rules of law. Okay, so if law of limitation is to be applied in a particular case of law, in similar case under equity, the same law of limitation will also apply. So equity adopts and follows the rules of law in all cases where it is applicable. Apart from that, equity also follows the analogies of common law. Okay, so the same way in which property under certain properties, okay, so certain estates under the law might be inherited, in the same way property under equity will also be inherited. So if someone dies intestate, then his heirs will inherit the property under equity in the same way as the property would be inherited under the common law. Now, when the question comes as to application of this doctrine, certain problems, conflicting issues, contradictory issues that come up. Okay, so historically it has been the case in England. Okay, so to what extent essentially is this maxim really applicable, okay, as is claimed, okay? So historically it was the case that in England the idea of primogeniture applied. So the firstborn child inherits property. The later ones are at disadvantage, okay? So that's the law. So if that were the case, equity will not interfere in such a matter, okay? However, there are certain exceptions to this situation. Okay, so what is that? Okay, so what happens is that, what if the eldest son, okay, before the father could make a will, okay, assures that he will take care of the other, children. Okay, so and hence in a way prohibits the father from making a will and then giving property to all other children. So what happens in that case? So now in this situation, because the eldest son, okay, who has by virtue of his own action prevented the father from making will, which would have ensured that other children also get their, a share in the property. Now, after this promise that has been made, now equity interjects, and subsequently after the death of the father, if the eldest children does not respect the promise that he has made, then he will be compelled to do so. So you see that although it doesn't really work, okay, directly, but it works subsequently. Okay, so in the first situation where equity says that there clearly is no property right of other children, okay, equity seems to follow it. It doesn't interfere. Okay, but once a promise has been made, okay, that under the law has no effect, but under equity it has effect. Okay, now in this situation, what will we say? Is the equity following the law, or is the equity going against the law? So that's a question that needs to be pondered upon. Okay, so yes, this is essentially what the maxim is all about. There are certain exceptions to this maxim, just like the other one that we had discussed. Okay, so what are those cases where equity proceeds to administer justice on principles and rules of its own? Okay, so there are, as I told you, the cases of what do you call it? Earlier we discussed that auxiliary jurisdiction. In those cases, you see that equity creates its own procedures. Okay, in certain others, it recognizes certain rights which are clearly contradictory to rights under the common law. So what about all those cases? In all those other cases, okay, equity proceeds to administer justice on its own principles and rules of its own. Okay, so in those cases it doesn't really follow the law, but in others it does follow the law. Okay, another limitation is that this maxim is subject to the other maxim. If you remember, the doctrine of ubi jus ibi remedium, okay, equity will not suffer a wrong to be without a remedy. So this maxim is subject to that one. In what sense? That here it's saying that equity follows the law, in the other it says that no, not necessarily, equity will not let anyone suffer without remedy. So what about those cases? They seem to be contradictory. So what's the utility? In fact, this is the question which is raised by Snell, that okay, so we can give examples on both the sides, sometimes where equity follows the law, in others where equity doesn't follow the law. So what's the point in saying that these maxims have any utility? Rather, we should focus on specific cases in which equity either follows or it doesn't follow the law. Anyway, so that's the second maxim. Okay, so today we will take up one more maxim, and then I will deal with the rest in other class. Okay, so I won't have much. I think after that I will have just 9 maxims. So in about week's time, 7 classes, we can complete that. After that we will take few rights, states under equity, and then my portion will be over. Anyway, the next important maxim is, he who seeks equity must do equity. So what does this maxim essentially say? It says that if you come to the court of equity seeking a remedy under equity, seeking equitable remedy, then you must be willing to concede on your part what you owe to other under the equity. Okay, so as you know, equity is a law of conscience, so it doesn't work like, hard and fast law, okay, as we discussed earlier, okay. So if a right is created under a law, either common law or statutory law, it is not conditional, in the sense that if a right arises under the provisions of the law, you are entitled to it. It doesn't ask any more question than that, okay, unless the condition is imposed by the law itself, okay. If it doesn't, okay, you have the right, okay. So it's clearly laid down. However, we discussed that court of equity is different from court of law, in the sense that there are certain discretionary powers, okay, that court of equity exercises. It functions based on conscience, okay. So that's where this becomes relevant, okay, in the sense that it exercises certain discretion as to where to provide you remedy and where not to provide you remedy. So one such case is the maxim that we are discussing here now, okay. So it says, he who seeks equity must do equity. So if you come before the court seeking remedy under the equity, then you must be willing to concede or do your part under the equity towards the other party. So when anyone comes to the court of equity to get a relief, okay, that he is considered to be ready and willing to recognize equitable right of the other party as against the plaintiff himself, okay. So you seek relief, the relief will also be, the deserved relief will also be given to the other party, okay. So what it essentially says is that, but then keep in mind, okay, I should not give you this impression that application of this maxim leads to creation of absolute equality between the two parties. No, it's not that case, okay. So it's quite possible that equity that I'm seeking in terms of weightage, okay, is much higher than equity that the other party is expecting, okay. So as long as there is this reciprocity, in the sense that I do my bit and you do your bit, okay, if that is the case, yes, this maxim is quite often applicable in that sense. Not always, but quite often it is applicable in that sense. So do not misunderstand this maxim to mean that both the parties will be put on equal pedestal. Not necessary. Maybe one party was guilty a little more than the other, so of course that party suffers a little more than the other, of course. So of course you cannot forget that part, okay. But what it essentially says is that you come to the court of equity seeking justice, so should you be willing to do on your part towards the other, okay. And quite often we see that this conflicts with certain other possible interpretations of the same law. So anyway, essentially the idea is that if a litigant claims something by way of equity, he must be ready and willing to grant to the other party that which belongs to that other party in equity, okay. So Lord Elhurst had said that in a court of law, we cannot impose terms on the party's swing, but if he's entitled to a verdict, law must take its own course, okay. On the contrary, court of equity is a court of conscience, so it can take into consideration of other factors, okay. So, but the court of law cannot, okay. So that's essentially is the doctrine. In another case by the name Sturgis versus Champneys, okay, Sturgis versus Champneys, Lord Cottenham had said, the court refuses its aid to give to the plaintiff what the law would give him, okay. If the court of common law had jurisdiction to enforce it without imposing upon him conditions which the court considers he ought to comply with, okay, although the subject of the condition should be one which this court would not enforce, okay. So what it essentially is saying is that if you were to go before the court of common law, then no such conditions can be imposed. However, the same is not the case when you come before the court of equity. So it says the court refuses its aid to give to the plaintiff what the law would give. So if you were to apply court of law, it will give, but under court of equity, it will refuse. If the court of common law had jurisdiction to enforce it, okay. without imposing upon him conditions which the court considers he ought to comply. So that's being referred to the common law court. Although the subject of the condition should be one which this court would not enforce. Okay, so anyway, that's essentially the idea, more complicated way of saying the same thing. Okay, so what it essentially says is that equitable remedies are not absolute. Okay, they are discretionary. So discretion exercised here is subject to, in this specific maxim, you conceding equity to the other party as well. Okay, so it's not just the plaintiff, not just the defendant, but also plaintiff who is expected to act conscientiously. So that's the essence of the maxim. Now, Snell, however, if you have read, raises certain questions about this specific maxim, in the sense that, does it really make sense to say that this maxim is of any use? Okay, in the sense that, is it applicable in all cases? Can we say that this rule is to be applied universally, in the sense that every time you come and seek a remedy under the under equity, you have to keep your conscience absolutely clear? Does it mean that you cannot do any wrong in your life? Would doing any wrong in your life would mean that somehow you're not entitled to this specific relief under this maxim? That's not the case. So so this happens is that in certain specific cases, in the same transaction, with regard to the same transaction or related transaction, where the two parties are concerned in the instant matter, in those cases, not in all but many, this maxim becomes applicable. So it's not as if every time you come before the court of equity, you have to come with absolutely clear conscience. That's not the case. Okay, so anyway, other criticisms have been provided. There you guys can always go back and study that. A very important case here would be Lodge versus National Union Investment Company Limited. Okay, why? Because this case will explain what happens in this particular. So this is there in the book, okay, in the relevant portion that I have shared with you guys. Okay. So what happened in this particular case was that the plaintiff had borrowed money from the defendant. Okay, so the defendant was an unrecognized moneylender. Okay, under a particular act known as Moneylender Act 1900. Okay, so under that act, okay, certain provisions provided that the contracts by any moneylender who's not registered under the act will be void. Okay, now the money has been borrowed, some security had been advanced by the plaintiff. So what he does subsequently is that the plaintiff sues, okay, demanding back the securities and the payments. Okay, so what happens then? The defendant then took the defense in this particular case that the plaintiff who's seeking equitable remedy should also be willing to do equity. That is basically pay back the amount. When you are asking for the security back, you pay the amount back. Okay. So the defendant was willing to give back plaintiff's money if plaintiff, pays back security. If the plaintiff pays the loan back. Okay. So what was held in this particular case is that the same said remedy as we have just discussed was made available. Okay. So court has to apply this particular maxim and did apply this particular maxim in this instant case. So I hope you guys understood what this maxim essentially talks about. So there are many applications of this maxim. Okay, so what are those? Okay, you have many such examples. We because we do not have a separate kind of law of equity they have in England, so we have them under the statutory law itself. So in England though, the one such application would be wife's equity to a settlement. Okay, so what is that? So as you know, in England prior to 1935, okay, before the Married Women and Tort Cases Act 1935 was enacted, wife had no property. Okay, once wife marries husband, her property gets merged with the husband's property, and then essentially under the law, wife has no property. But subsequently, Court of Equity recognized this particular property right of women. Okay, so under the law of equity, a fair settlement of part of the property on the wife and the children has to be done by the husband here. So that's one such case where this was applied. And then there are cases of unconsumable bargains. So basically when two different parties in a contract are not at equal pedestal, then because of that inequitable bargains might happen, in the sense that one might be able to impose because of the inferiority in position of the other party certain terms on them. So in such case also this maxim could play a part, in the sense that when one party seeks equity, the other party is also expected to do his or her part. So yes, essentially any such example you can come up with, there might be application of this particular doctrine. So same applies to the idea of specific performance. So in specific performance, one of the party demands that the other party specifically performs, respects his or her side of the contract. Okay, so in such case, specific performance does not happen only on the one side. The same happens also, if possible, on the other side as well. So yes, that's another application. And then it applies to something that you guys have also studied under election. If you have studied election under the Transfer of Property Act under section 35, okay, it talks about election. So essentially what happens in election, one example I'll give is, so for example, I gifted property in favor of B under an instrument, and by the same instrument I transfer the property that belongs to B to C. Okay, so what happens is a very simple example. Okay, so what happens here is that I gifted property to B, but under the same instrument I also transfer a property that does not belong to me but belongs to B to C. Okay, so this is all in one instrument. Now B has to elect here. Okay, between what? Between keeping his property and accepting what I gifted. Okay, so B either accepts my gift. Okay, B accepts my gift, then B has to allow transfer of that property, his property, in favor of C. And if he doesn't, then he doesn't get to keep the gift that I have given to So that's doctrine of election. So what you see is the application of this maxim. So, but then, as I said, these maxims are not generally applied now. Okay, they have become very ossified in those specific cases that we are discussing. This maxim essentially applies. So the chancellor, the Court of Equity does not get to exercise the same kind of discretion as it would have earlier. So under Transfer of Property Act, okay, you have section 35 that talks about election when necessary. So quickly, just 1-2 sentences will suffice. Okay, when a person professes to transfer property which he has no right to transfer, as I said, okay, I transferred B's property, I had no right to transfer, and as a part of the same transaction, okay, confers any benefit upon the owner of that property. So for example, I give him certain amount of money. Okay, such owner must elect either to confirm such transfer or to dissent from it. So you either accept it whole or you don't. Okay, if you accept it, then the property will be transferred and you also get entitled to what I promised to you. And in the latter case, okay, he shall relinquish the benefit so conferred. Okay, if you dissent, then you do not get the benefit that I have conferred. So for example, whatever money or something I promised, okay, the benefit so relinquished shall revert to the transferor, okay, or his representative if it had not been disposed of. So anyway, so the rest of the part is not that important. So example will be more or less what I had already given you. So this is the doctrine of election, that you should, if you are expecting equity, you should also be willing to concede equity on your part. Okay, so some other examples have been given. So for example, compensations for repairs and improvement. Okay, so Helsbury had said that when a person in possession of property has under mistaken belief that he is entitled to it spent money in permanent improvements, the true owner, if he has the claim, if he has to claim his title in equity, is required to do equity by repaying the money. So for example, you are in possession of a property but that in equity belongs to someone else. Meanwhile, you have made certain improvements in the property. So subsequently, if the person in whom better title resides wants the property, then he should be willing to pay for the improvements, permanent improvements that you have. So remember, permanent improvements, because it becomes permanently affixed to the property. So for that, you have to repay your bit. So same, it's more or less the same thing that I've been repeating. So what happens essentially in all these cases is that one party seeks equity, then the other party also seeks equity. So if you expect the court to do equity in your favor, you should also be willing to do equity towards the other party. Okay, so yes, these are some examples. Okay, we have already discussed one under the Indian the Transfer of Property Act. There are many others. So for example, under Indian Contract Act, section 19A says power to set aside contract induced by undue influence. Okay, so unconscionable bargain, these are more or less of the same nature. Okay, so what does it say? When a consent to an agreement is caused by undue influence, the agreement is a contract voidable at the option of the party whose consent was so caused. Yes, the option is, of course, in the hand of the person who didn't properly get to exercise that choice there. So yes, what happens? Any such contract may be set aside. So if that is the case, it may be set aside. Okay, either absolutely, or if the party who was entitled to avoid it has received benefit thereunder. But what happens there? Okay, upon such terms and conditions as the court may seem just. Okay, so in such case, the court may also say that the other party that is claiming the benefit in this particular case of the application of this provision should also be willing to. So for example, if he or she has received some benefit, court may say that give it back. So that's what the last sentence says. Upon such terms and conditions as the court may seem just. So these are the things that you guys have already studied. These are under the statutory law in India, but they had historically emerged under the law of equity. And the same applies for section 64. Okay, concessions, consequences of rescission of voidable contract. Okay, what happens when a contract which is voidable, okay, is rescinded? What happens? So it says, when a person at whose option a contract is voidable, okay, rescinds it, the other party thereto need not perform any promise therein contained in which he is the promisor. Okay, the party rescinding the voidable contract shall, if he has received any benefit thereunder from another party to such a contract, restore such benefits so far as may be. So you see the same thing. Okay, rescission happens, then you should also be return back what you gained from it, okay, to the person from whom it was received. Okay, so the same application of the same. Okay, so there are a million other provisions that we can talk about. Let's take two more provisions. Okay, one is specific relief act under section 28. So I'm referring to these provisions. You won't find that in the reading that I have shared. So kindly go back and read these for clarity of understanding of this specific provision. Okay, so under section 28 of specific relief act, okay, it talks about what restoration of possession in sale of immovable property in case of rescission. So if a rescission happens, then restoration of property will also happen. Okay. Similarly, Transfer of Property Act Section 51 says, okay, improvements made by bona fide holders under defective titles. Okay, just like the previous case that we had discussed. Okay, under the English law, when the transferee of immovable property makes any improvement on the property. Okay, so when the transferee of an immovable property, for example, I am the transferee, I made certain improvements on the property, believing in good faith that I am absolutely entitled thereto. I am under no other impression. Okay, and I am subsequently evicted therefrom by any party having better title, someone having better title. The transferee, me in this particular case, have a right to require the person, for example, someone who caused the eviction, okay, causing the eviction, either to have the value of the improvement estimated and paid or secured to the transferee, or to sell interest in the property to the transferee at the then market value thereof, irrespective of the value of such improvement. So essentially the idea is same, that some kind of approximate equality is maintained here, that if I'm seeking equity, I should also be willing to concede. So that's it, that's the maxim. Okay, now one more thing that I would like to talk about here is that it's essential that, see, like all maxims, okay, as Snell has criticized, okay, these maxims are not universal. It's not as if judges in deciding a particular case can forget about all the precedents, all the laws laid down, and then say that I'm deciding this particular case based on application of such a wide general maxim. They cannot do so. But in arriving at a decision, okay, in a particular case, then you might find them citing this maxim or that maxim here and there. So yes, to that extent, these maxims are important in showing the rationale which was revealing the rationale which is applied by a judge. But then in this particular case, we started with this thing that there's a limitation that you cannot forget about application of this maxim. That is, he who seeks equity must also be willing to do equity. And what is that limitation? It is that it applies in the same case. So in all the examples that we have